Hi everyone. So in this video we will be covering question number 2 and 3a, the next set of questions as a part 3. So let's go immediately to the question paper, which is question 2. So the defendant company make a rough layout of its land by dividing it into plots, roads and common areas etc. and offered them for sale. So the terms of this offer are given as one should pay the initial down payment. So the buyers should pay first the down payment, and after which the defendant company would complete the development of the layout. So after paying the initial down payment as a token amount by the buyers, the initial down payment will be treated as a token amount, and then the company will complete the development of the layout. So the defendant company would seek payment of remaining consideration. So the rest of the consideration other than the initial down payment can be paid after the development of the layout in the land and register the developed plot after receipt of the payment of the balance sale consideration. So by this you can understand, we'll just simplify. So here there is a company A, for suppose. So a company A has offered the buyers that it is giving some plots for sale. So the company has some layout and it is giving some plots for sale, and the interested buyers, they can come and they can pay the initial token amount such as down payment. So initial token amount is taken from the buyers. Okay, so after this, what does the company say is, the company says after taking the initial token amount, with that amount the company will complete the development process. So the development process of the entire layout, and after the entire development process is completed, the company will give the buyers, those who have paid the initial amount, the land or the plots after taking the rest of the consideration also. That means after taking the full payment, then they will be giving the developed layouts to them. So till here it's clear. So now what happened? The plaintiff agrees. So here the plaintiff is the buyers. So the plaintiff agreed to purchase a plot and enter into a written agreement. So one of the buyer, what he has done is, he agreed for this terms and conditions and he has entered into a written contract containing all these about terms and about the initial payment. All the terms and conditions he has read and he has entered into a written contract. So while the development work was going on, what happened is the government requisitioned the land. So what is requisition? It means the government has passed an official order to use that property or some materials or that premises for temporary purpose. So here what happened is, while the development work is going on, so people has paid the token amount, and while the development work is going on, the government has passed an official order stating that this layout which is used for the development by this company will be taken by the government for temporary purpose, and agreed to return the land after the government's purpose was completed. So this is what the government has passed. So now here the company, the defendant company, it is not sure that when will the government return its layout which is taken for the government purpose. So what it has done is, it has informed the plaintiff, the buyers, about the requisition of the land and the offer, and the company offered two alternatives. So here the company said about what all happened and the government order which is passed, and after this all happened after the company has taken the initial down payment, right? So during the development process, the government want to use the land for some temporary purpose, and this has been known to the company, and company has said this to all the buyers. So in that, our plaintiff is one of the person. So, and the company has given two alternatives. So what are those two alternatives? We will see. In the first alternative, it offered to treat the contract as terminated and return the initial payment. So whatever the amount is paid by the buyers, it said under condition 1, what we will do is, as we are not sure when will the government return the land to us back, so we'll be giving back your initial payment and treat this contract as terminated. And what is the second alternative which the company has been stating is, it offered to receive the remaining sale consideration and execute the sale date. Okay, chalo. The second one, what it states is, pay us the rest amount which is balance. After paying the amount in full, we will execute the sale deed. So while referring to this development of the land till it was returned by government. So what they are telling is, initially before when the buyers have agreed, so the company said after taking the initial down payment, we will be developing the land. So as the government has took the land for temporary purpose, so now it is stating that even though you pay the amount in full, we cannot develop the land and give, but we will just execute the sale deed on your name. So this is the second alternative given by the company. So here the plaintiff refused both the offers and insisted that defendant company should stick to the original terms and conditions of the contract. So he has signed the written agreement and it has been written that the company should give all the development process after taking the initial amount. So the plaintiff is asking, stick to the initial terms and conditions which we have signed earlier, and to develop the layout by taking the remaining sale consideration, and then you have to register the sale deed. So as the defendant company refused to develop the layout, the plaintiff filed a suit for specific performance of the original terms of the agreement. So what are the pleas that can be taken by either side, and what is the decision in such case? So this is our question. So hope you understood our question. We'll be just explaining here once again. So A is a company which is giving plots for sale. So all the buyers has come to take the take this contract into consideration, and they paid the initial token amount. So after paying the initial token amount, the company A said that with your token amount, we will be developing the layout. So we will do the development process. And after this process has been completed, we will be taking full amount, the rest of the pending amount. And after taking the pending amount, we will execute and register the sale deed. So in meanwhile, what happened is, after taking the token amount during the development project, here the government has entered. And it said to company A that it will be taking these plots for temporary purpose for the government, and later it will return after its purpose has been completed. So after this has been ordered, the company has said to all the buyers that so and so issue has been happened, so we are not sure when will the government will return the land. So in meanwhile, we'll be giving you two alternatives where you can treat the contract as terminated and we will return the initial payment. Otherwise, you can pay the remaining amount also. So you can pay the remaining amount. We will execute the sale deed, but we will not continue the development of layout process. And one of the buyers did not agree for this, so he is our plaintiff. So now what happens in this scenario? So in this question, they are asking what are the pleas taken by either side and what would be the decision in such a case. So here, obviously, when a government has passed that order, you will find in the website of the government such official notice, whether it is true or not. So the plaintiff can check that, and upon that, the plaintiff has pleas to ask for specific performance of that contract. But here there is a scope of filing PIL, public interest litigation, because here there are a lot of buyers and it is on a larger area that this situation has happened. So there's a scope to file PIL bill, and the plaintiff please can be, he can also ask for breach of contract, as the defendant company has failed to fulfill its obligation which has been signed in the written agreement as stated. So here the plaintiff stated that the plaintiff agreed to purchase a plot and enter into a written agreement. So as per the terms and conditions, here the company A did not go as to the fulfilled obligations. So here he can file for breach of contract also, right? Next. So what are the pleas taken by defendant then? So what pleas can be taken by defendant? So far you have come to know what pleas can a plaintiff can be taken and what pleas can be defendant taking. So we'll be seeing pleas on side of defendant. So he can start by saying that he have done this development layout plots ka idea with a good faith, and it is not to fail the entire contract, or it is not either to blame anyone else, or it is not to make a false allegation. So they have done this on a good faith to develop the plots and give for the buyers. And he can also state the other plea to defend himself, stating the impossibility. So why it is impossible for the company to accept the plaintiff pleas, and he can give the valid reasons. The company can give valid reasons for the impossibility to perform the contract. And they can also plead stating that as it is impossible for them to perform the contract because they have not known the government time limit, when will the usage of the temporary purpose will be completed. So as there is no specification of the government time limit, it is impossible for the defendant company to complete the performed contract as stated, right? So next, alternative offers. So the company can also say that it has performed alternative offers to the buyers. So as the company is not having any options, it has performed the alternative options to the buyers as stated in the question. So option 1 is to terminate the contract and option 2 is to execute the sale deed without any development of layout. So these are the pleas or the arguments raised by the defendant and the plaintiff. So in this scenario, what will the court do is, the court will look into all the terms of the contract which has been signed and also the government notice which has been shared for the requisition of the said property or the land, and whether the defendant company is showing some reasonable cause, and if government has taken this land for requisition, what is the impact and what is the ability to perform still this contract, and whether specific performance in such a situation can be variable and can it be a equitable remedy. So all these scenarios will be taken into consideration and then the decision in such case will be given. So we have completed the question, what are the pleas that can be taken by either side and what would be the decision in such a case. So you have to elaborate your question which you have understood, like given so and so and what you understood from that, and then write regarding the plaintiff arguments of the pleas and the defendant scenario. So the next question we'll be going through is, if a decree for recovery of money is silent regarding the payment of interest from date of decree to date of payment, what is the remedy available to the plaintiff? Can a separate suit be filed? So first, to understand the question, they are talking about in particular should you ask about payment of interest? So generally what happens is, in many cases separate suit is not required. So suit may not be separate suit may not be required or necessary to claim the interest, because this will be by automatically, it's by default, the interest will be calculated. So what happens here is, the remedy available to the plaintiff, it entirely depends upon the circumstances of the such case, and no separate suit may be required or necessary to claim the interest again in a separate suit. So that is the answer. And while talking about what are the other options where the plaintiff has in this scenario is, so the provisions it can have to automatically grant, the provisions having automatically to grant interest on such money decree by default. But in some cases the plaintiff still can apply to the court which passed the decree. So he has to make an application to the court, which court has passed that specific decree, or the relevant authority, to compute and calculate the interest amount. So for this, separate lawsuit is not necessary. He can just apply for the court for which the court has passed the decree. He can go to that said particular court and ask to compute the said amount of interest for this money recovery decree. There is another option to the plaintiff also. What he can do is, he can negotiate with the debtor to reach on some specific agreement regarding the payments. So there can also exist a settlement of contract in this, if negotiated and if agreed by the defendant or the debtor. But still, if the debtor fails to pay the interest amount, then enforcement proceedings can take place. So all this scenario is, by default a payment of interest is also calculated from the date of decree to the date of payment. So no such separate suit is filed, but in fact the plaintiff can reach out to the court which passed the decree for a simple application. So in the next video we will be covering few of the questions. So stay updated, do not miss, and if you like this video, do not forget to like the video and share. Thank you.